It's Sarah Bundy here with All Inclusive Marketing, and I've got a really interesting guest with us today whose name is Andrei Mincov. And Andrei has been a lawyer for over 15 years, specializing in intellectual property, and has just recently launched a new venture called the Trademark Factory. He's also the owner of Mincov Law Corporation and has some really interesting thoughts and ideas around what merchants and internet marketers need to know about working with trademarks in the online space. So we kind of wanted to have an open discussion about this. We're going to have an open conversation and just sort of see where this takes us. But I think there'll be some really great tips that both retailers and internet marketers can take away from this conversation. So my first question for you, Andrei, is what is it that retailers, the merchant, the seller, needs to know if they're going to be taking their brand online? This is in general and, of course, from a trademark perspective.
Well, the first thing to consider is that whereas the laws on trademarks are national in the sense that there are different laws in the States, they're different compared to Canada, Europe, or other countries. And when you're selling your stuff online, that's where you don't have that nationality aspect. So sometimes you have to think about your markets first to see where you want to look for protecting your brand. And sometimes it's going to be beyond the major markets where you're selling offline. So it just becomes a step in the strategy to figure out how many sales are you going to have outside your normal jurisdictions when you're selling online. And if there is a lot of those sales, that's when you may want to consider also filing for trademark protection, doing other legal steps in those other jurisdictions.
Okay, and what about the internet marketer side of things? So let's say you're promoting someone else's brand. What are things that you should be aware of if you're going to be complying by the rules out there? And kind of what are the things that you can recommend to people about working with other people's brands?
Well, the general rule is if you are selling somebody else's product that you physically have in your hands or that you're allowed to sell, then it's not a trademark infringement for you to use that trademark. So, for example, if I'm reselling my iPhone on Craigslist, I'm not infringing anybody's trademark rights if I'm saying that I am selling an iPhone. It's not the use of a trademark in that sense. But as soon as I start creating an impression that I'm the dealer for used iPhones, that's the only thing I do, that's when I can run into problems with a trademark owner. So that's the first thing to consider. And the second thing to consider really is that it's a lot more important to look at the agreements and the contracts that you are entering when you are being allowed to distribute somebody else's products or services online. Because sometimes the trademark owner may not have a registered trademark in your jurisdiction. They may not have taken proper steps to protect their stuff. But when you do bind yourself with some of those terms and conditions of those agreements, you may actually agree not to do certain things that you would have otherwise had the right to do. So that's what I always tell my clients. A contract can be a lot more powerful than any registration, than any law, because that's where you can create rights and destroy rights.
Got it. One of the challenges that a lot of merchants face in the online space is the issue of trademark bidding. So you go to Google and someone is bidding on a registered trademark term. That person or that corporation, whoever is taking that action, can either be a partner or a competitor. What is it that, how can people deal with that issue in your experience, and what should people know about that particular example?
This kind of continues the issue that I've just touched on, the contracts, because in most of the cases, the legitimate affiliates would be told whether or not they can use the trademark in their SEO and in their advertising bidding, and whether they can and how they can do it. right? That's one thing. For competitors, it's a different thing, and obviously they don't have any permission, and in many cases, trademark owners get really upset because that leads to dilution. That's a form of passing off, whereby you create this interest in your product by using somebody else's trademark, and that's not something that you can get away with if the trademark owner decides to go after you. There's a lot more case law on this in the States than, for example, in Canada, but there is some. And the idea really is to see if the risk is worth it, because most of the trademarks are owned by, I mean, if you are reselling products that are offered by a rich, big company, they probably have enough money to take you to court, whether or not it's worth their while or not, because that will be done for the principle of protecting the brand. So in that case, your risk is much bigger. On the other hand, if you're dealing with a smaller company, then the risk is smaller, but also the reward of attracting internet users to that brand is also smaller, because less people know of that brand.
Makes sense. So I'll ask you one last question for this particular video. Could you tell us, how would a company decide if they should register their trademark or not?
Do you mean the affiliates or in general?
In general, like a merchant, like why would they register their trademark? Like, do you have a process that you use to determine that?
I use a process that I call the Trademark Factory. And really, it's a 3-step process. The first step is to determine whether there is something trademarkable. And the function of a trademark is to distinguish your products and services from somebody else's products and services that are identical or similar to yours. So the function of a trademark is not to compel somebody to buy a pizza over a burger. The function of a trademark is to allow you to choose one burger from a different burger, right? And on top of that, you have to see if your trademark is not does not fall under several categories of trademarks that cannot be registered based on the trademark laws. So once you've discovered that you do have something trademarkable, the next question then becomes whether you should get a trademark. And for that, really, there's another simple process, 3-step, 3-question process that I use with my clients. The idea is the business owner should ask themselves 3 simple questions. 1, would it be a problem if I was forced to change the name, the slogan, or the logo that I'm using for my business? So will I lose money on that if somebody says, you have to change the name because we own the trademark first? The second question to ask is, if your competitor started using that same name, logo, or a slogan in their business to promote their products and services, would you lose any customers over that? Would customers be confused? Would you be getting less money? And the third question is, if you were at some point in time deciding to franchise out, to sell the business, or expand to other markets, would owning that trademark registration give you more money? So if the business owner thinks that it's a yes, it's a loud yes to at least one of those 3 questions, then my recommendation is, of course, to get it registered as soon as possible, because even if you're right, it's a lot easier to fight the dispute if you have a registered trademark, as opposed to just trying to prove to the judge that, yes, you've been using this mark for 5 years but didn't register it. You may still probably win that case in Canada and US and other common law countries, but it's going to cost you tens and tens and tens of times more than if you were to simply invest in the registration. So it really boils down to the benefit cost analysis.
That's great. Well, I appreciate your time, Andrei, and your insights on the subject. If anybody wants to contact you to learn more about it, what's the best way to reach you?
Well, first of all, thank you for having me over. The best way to reach me would be by phone, which is 778-869-7281. Or you may visit my website at trademarkfactory.ca. or mincovlaw.com. That's mincovlaw.com.
That's great. Thanks so much, Andrei. We'll talk to you soon.
Thank you.
Bye.